SJC number 12186, Commonwealth versus Heather Dragotta.
Mr. Levin, good morning.
Good morning, Chief Justice Gantz. May it please the court. Patrick Levin on behalf of Heather Dragotta, who appeals this morning from a conviction of recklessly permitting her boyfriend, Stephen Amos, to injure her infant daughter, Autumn. In my brief, I framed the legal issue before the court this morning as the point at which criminal liability attaches to one parent for an injury unintentionally inflicted upon a child by the other parent.
So the Commonwealth takes issue with that.
The Commonwealth takes issue with that characterization, and they're very dismissive of the idea that the unintentional nature of this injury is relevant to this court's determination this morning. And they're right that it doesn't provide a defense for Stephen, because the assault and battery upon a child under Section 13J is not a specific intent crime with respect to the injury, but it's very relevant to Heather's conviction, because the kind of person that Stephen is bears to a great degree upon Heather's mens rea in this case.
But I mean, do you need to go there? I mean, whatever Amos's intent was, isn't the question what was the evidence available to your client that would put her on notice of X, Y, or Z?
Yes, you're exactly right, Justice Botsford. And that's what I'm getting at, is we would have a very different case here if there was some evidence that Stephen harbored some animus towards this child, that he meant to hurt her. That one of the only two cases that the appeals court relied on in affirming the conviction, Commonwealth versus Rodriguez, is a good contrast case, because there the evidence suggested that there was in fact an intentional battering is the word that they used, but that the boyfriend in that case over an extended period of time essentially was beating this baby, and that the defendant in Rodriguez was present and saw what was happening and didn't do anything about it. And it's clear what the recklessness is in that kind of a situation, that there's a duty to act and a failure to abide by that duty.
Aren't we using an objective test?
Yes, Your Honor. I think the case has mostly been argued on an objective basis.
So if your client objectively would have realized there was a danger from these so-called maneuvers, then your client would be liable.
That's essentially right, yes. That if a reasonable person in her position would have known that there was a substantial likelihood that her partner was going to inflict a serious injury on the child if she left them alone for a few minutes, then this conviction is correct.
Mr. Levitt, is it true that we have to narrow the factual focus to that one incident where she went into the shower while Mr. Amos, is that the sum and substance of the case?
That was the basis of the only indictment that the judge convicted her on. There were 3 indictments, and she was acquitted on the other 2.
I take it the theory of the Commonwealth is that although she wasn't convicted of it, that the prior incidents of the bicycle or the failed or improperly performed bicycle maneuver would have put a reasonable person on notice that something was amiss, and the child should not be left with him.
Yes, that's the theory. And I want to emphasize the point that I made in my brief, which is that there just is no evidence that she saw him doing something that hurt the child more than one time.
But
Well-
didn't she use the maneuver often, consistently for a week or so? And when the boyfriend used the maneuver, the child had a reaction?
So the evidence is, in terms of the child's reaction, the evidence is that not often, but sometimes she would cry when he did this.
And get red in the face?
And there's some conflicting testimony on this point, but if you look carefully at the DCF investigator, Amy Silverio's cross-examination, she specifically asked to affirmatively choose between the two versions, what she said on direct examination and what is contained in her written report, which is contemporaneous with the interviews that she conducted. And she specifically says that she stands by what's written in the report. She disavows the earlier testimony. And so the evidence that the judge was entitled to credit is that sometimes, but not often, Autumn would cry when he did this.
Was there any evidence that after she told him to stop doing it, that he did?
There is evidence
That he kept going?
That he
Is that you-
that he did it after she told him not to do the bicycling adaptation?
There is evidence that he kept doing it for another week after she told him to stop, but there's no evidence that she ever knew about that. All of the evidence in terms of her knowledge,
And would that not be a reasonable inference because of their living situation, that she would know, even though she didn't say that?
no, it's a two-bedroom apartment, and the evidence was that he often would take her into
Child.
another room to change the diaper, which is, this maneuver is linked up to the diaper changes in the evidence.
Now, what do we do with the medical evidence that says that the force that was used with regard to the bicycling was a force associated with a motor vehicle collision?
So, two things to say about that, and I want to make sure I get to both of them because they're both important. But first, I just want to push back on that a little bit. I think it's a misreading of Dr. Kleinman's testimony. He repeatedly refuses to quantify the amount of force that would be required to cause these fractures. He says he can't testify about how much force, he can only testify about what types of forces, and that this testimony only relates to one specific set of fractures. They're the rib fractures near the baby's spine. And he says that fractures in that location are not typically caused in ordinary household accidents, but instead the mechanism for that kind of injury is a compression of the chest. And on cross-examination, he talks, there's a little bit of a back and forth about CPR, and he says that there's sometimes seen from CPR or from difficult deliveries where the chest is compressed. But the thing about the car accident is he's saying that he doesn't see these types of injuries from accidental causes except for high energy, high velocity accidents. But he doesn't speak to the amount of force that would be required to cause them through the mechanism of a compression. And in fact, he specifically says that it's outside of his area of expertise to characterize that the amount of force. The other thing that I wanted to say about that is that, again, it only relates to this one specific set of fractures, and it would require speculation to think that the one occasion on which she saw him inflict an injury is the same occasion when that specific.
But didn't she herself say that there was a causal connection between what the boyfriend had done and the child's injuries?
Yes, she said once she heard that the x-rays had revealed these fractures, so once she was told that the child's ribs were broken, she realized that what she had seen him do might have caused the injury.
But not to state the obvious, that's not available for the mens rea.
That's right. It's not until after, I don't think that her realization after she was told that the ribs were broken.
That was in the interview or the police?
It was during the interview with the DCF investigator and the police, yes. So I don't think that provides any insight. I mean, it certainly shows that at least one time she saw him pushing too hard. And I think that that's fair to say, that there was one occasion, and it's in her,
Doesn't it show that she has a realization that what he was doing was dangerous?
yes,
If
but
she comes to that realization.
well, once she discovers that the child is injured, she has realized that what he did was perhaps more dangerous than she previously thought. But that can't tell us anything about what she knew prior to the x-rays being taken. And all of this has to be viewed in the context of the only evidence about what a caretaker of this child would have noticed based on the injuries that were present, which is the Commonwealth's expert testimony from Dr. Wilson that it would have caused her to be fussy, but that a caretaker would not be able to distinguish that from fussiness because she's cold or because she's hungry or needs to be changed. And the specific testimony that a doctor examining this child would not necessarily notice these injuries at all. And I just can't see how it's reasonable to think that a first-time mother during the first month of her new baby's life, based on fussiness that would not cause alarm to a medical professional, would know that her partner is extremely likely to substantially injure their child if she goes and takes a shower and leaves them alone together, which is what we're talking about here. She left him to watch the baby while she took a shower. She's not, out partying. She's not. This is from all outward appearances, a model home for raising a child. There's no evidence of domestic violence in this household. There's no drug use. There absolutely is no reason, based on the evidence admitted at trial, for her to have thought that this man was dangerously unfit to care for a child. If there's no more questions, I'll rest on my brief.
All right, thank you.
Thank you.
Slingerland, good morning.
May it please the court, Marcia Slingerland for the Commonwealth. The trial judge here found that the defendant plainly knew that her boyfriend was mistreating this child before the guitar incident, and the evidence supports his determination.
What would be the evidence that supports it?
Okay. There's testimony, and again, this is a required finding standard, so in the light most favorable to the Commonwealth. The evidence would show that starting about May 11th is the date that Ms. Dragotta learned of the bicycle maneuver. She told Amos that day about the maneuver. He used the maneuver, decided it didn't work, and started using his own maneuver. The testimony was that while they were living in New Hampshire, which was on May 11th, they began to move from New Hampshire to Massachusetts between May 14th and May 18th. He's doing the maneuver, his own maneuver, the knees into the belly maneuver, while he's in New Hampshire, while they're in North Andover, and then he stops in North Andover. There's testimony that from Ms. Dragotta telling the DCF investigator that this happened pretty consistently. It was done pretty often, pretty consistently for about a week or so.
What do we do, though, that the judge found her not guilty of the charge that related to that?
Because I understand his rationale to be it was that maneuver that put her on notice. Arguably, he's starting to do this maneuver, and maybe he found that she hadn't got enough notice, or maybe he gave her a break. But clearly, he found his finding was that there was mistreatment before the guitar incident, which happens on Memorial Day weekend. So what the defendant reasonably should have known in the circumstances was that he is engaged, he doesn't know how to handle a child. She knows that. She knows that. He's gone off on his own tangent, and he's doing his own maneuver, which is causing the child to cry. There's testimony from both.
Is that a problem if it's similar to what the doctor had suggested? I mean, that makes sense, doesn't it?
That the doctor is suggesting?
His variation of the bicycle move, he thought it worked. He said it worked, right?
That's what he said. The defendant here didn't say anything about that. What she said is that the baby would cry. When she's asked by Silverio, what would have caused this? And she said the maneuver, and the fact that the baby, this is a 2.5 to 4.5 week old child, and I think it's reasonable to infer the child is experiencing some distress when the cry is happening at the time of the maneuver. And this is not a maneuver that the pediatrician said was okay. And this defendant knows that it's different. She's very clear on that. It's a knees, you push the knees up into the stomach and down. So that is a compression of the chest, which is consistent with the radiologist's testimony as to the type of injury, a type of force that would cause these injuries.
What's the reaction of the child? You said the child cried. Were there other reactions that would put her on notice of that it was harming the child more than the discomfort that was attendant to her
Other than the
condition?
one time.
Well, I guess my position would be, over the course of a week, we have a very young child, and there's the crying associated with the maneuver. There's the time where she says she recognized the child, that this may be too much for the child. So clearly she's on notice at that point that the child is being mishandled.
I'm a little confused. When did she see the pediatrician with the child, or does?
May 11th was when he showed her the bicycle maneuver.
And she doesn't see the pediatrician again.
Right.
With the child.
Right,
So no one sees the child
No.
after the maneuvers
June
have been
3rd.
done
until June 3rd when they
until
presented.
the X-rays.
That's right. So there's a 2-week, from roughly May 11th to June 3rd, that's when this is happening.
It's happening, but she's not getting it checked by a pediatrician.
No.
The child's not crying to an
But-
extent that she needs to take the child to the doctor.
I guess I would differ as to, and you can look at the record.
Yeah, I mean, because it's a new mother and everything, you think if the child was really crying a lot, or really fussing a lot, that she would be taking her to the doctor.
She didn't.
Well,
Well, she did as soon as
As soon as the arm was
the
broken,
arm,
no, but I mean,
but she didn't realize that the arm was broken. She knew that
she knew there
pain
was
in the arm.
something wrong.
Went immediately to the ER.
That's right. And
Your brother, he's not really her brother, but we call brother, says that after she said, you really shouldn't be doing that, that she had there's no evidence that she knew that he was continuing to do that. Do you agree?
I think it depends on how you read the timeline here. There's testimony that he continued for about a week using it. And if you're looking at the timeline, you're talking May 11th, 12th, 13th, 14th, 15th. So maybe you end up in the week before Memorial Day is when it would have stopped. It's not clear exactly when it stopped, except that if you take, and again, this is in the light most favorable of the Commonwealth, if you take,
Yeah,
that
take-
she
take
would
it
have
in
known
light,
it is
yeah.
the question.
Right.
I'm sorry, should she have known that
That he did not stop it, even though she said, please stop doing that.
I guess the point would be that she should not have left the child because she knew enough about what he was doing to the child, causing it to cry. I mean, what else are you going to hear from a?
So your position is that now how old, by the way, is Miss Dragotta at the time?
I believe maybe early.
19?
The defendant here? I'm not sure. I thought she was older,
So
but
we,
I'm
we
not
have, we
positive.
have a first-time mother
Yes,
and a first-time father, who we know is not the biological father.
right.
And she sees him do something with the child, and she says, you know, that's too rough. You should stop doing that. And your view is that as soon as that happens, a mother has an obligation to not permit that person to touch the child again?
I think she should, a reasonable person in her circumstances would, if you look at all the evidence that she knew or should have known, that the child, there's a high likelihood that that child would be subjected to substantial bodily harm based on the crying. And also there's testimony by Dr. Wilson. The broken leg would have caused the child fussiness and to cry. Also,
Babies fuss and cry all the time.
yes, but not in connection. I mean, it's clear that if the child is responding and expressing distress by crying at the time this weird maneuver is being performed, that should alert somebody, hey, he's a first-time person, he doesn't know how to hold a child, and look what he's doing, and that's okay?
So the objectively reasonable basis to find her liable is that she knew from May 11th to June 3rd that he was doing this constantly, and when he did this, she would cry. The baby would cry.
That's correct.
Well, let me ask you this. The x-rays showed broken ribs, right?
They did, yes.
Okay, wouldn't a child, or anybody for that matter, with broken ribs, I mean, wouldn't you expect a reaction that would cause you to run to the ER? I mean, this crying is just happening when he's doing the maneuver. It's not something that's persistent, right?
Well-
so if there's this kind of injury, how would she know that that's happened by the child's reaction?
There's testimony from Dr. Wilson that if the child was lifted, because this baby doesn't move or roll or hold up its head or do much of anything, that if you lift the child up, the child would have been fussy for the broken ribs.
There was testimony from the mother, that is Ms. Dragotta's mother and sister, but it wasn't, I didn't get the impression that they would say the child could be fussy and would cry, but it wasn't, nobody said it was more unusual she had 5 children.
That's right. And when they were residing in the home in Ware, Mom was helping out. She was taking the baby at night. There were a lot of people in this open layout house. However, when they moved to Massachusetts, things changed. There was nobody there to be up at night. It was the two of them. And so Ms. Dragotta and Amos were there in this house together, 2 bedrooms upstairs, an open living room connected to a kitchen. It was not a large house. I think there may be 12 to 1,400 square feet, there may be. But so they're living in this house, and she knows what his maneuver is doing to the child. Also, if you would take a look, to understand the sort of compression that might to help you understand what is involved when you're pressing on a chest, that's very consistent with exactly what the radiologist said. There's Exhibit B for identification. The radiologist explains very clearly exactly what happens. And there's a diagram that shows the rib cage and then when it's compressed and how those injuries to the spine occurred. There are 22 fractures on this child, 7 of which are on the back part of the rib cage, which the radiologists testified were extremely unusual in infants, overwhelmingly seen in victims of abuse. And not only that, there were 2 lateral fractures.
But the point is, did she know? I mean, everybody understands that the injuries happen. The issue in this case is, what did she know and when did she know it?
Right.
And I'm just not getting a clear picture here that there was enough happening in that house, at least as far as the child was concerned, to clue the mother in that something really bad is happening here. You got broken ribs. You expect a screaming child
fussy or crying when the extremity is moved.
Screaming, I mean, if you break a rib, don't you scream out loud? And
Was there evidence specifically, other than the maneuver, that she cried when the extremities were moved?
The doctor said
doctors-
that's what would have happened.
Yeah, but
But
we
there
don't
was,
have any evidence that it did happen.
it's just what you might expect.
Well,
The
between the-
grandmother, excuse me,
Go ahead.
the grandmother did have some contact with the baby, I think, in this period of time, didn't she? Because didn't she say something about some kind of a noise or something she heard or felt in the baby's back?
That was when they were living in New Hampshire, a crunching sound,
Yeah, but they called the pediatrician and who said, don't worry about it.
especially because it wasn't painful.
Yes, but so this has nothing to do with the fractures?
No.
Oh, okay.
Can I just ask, why are we saying that she should not have expected Mr. Amos to stop when she told him to stop? Is there anything to say that in the past she had told him not to do things and he still did them?
The evidence on that point would be that she had told him what the doctor had showed her. It was a gentle maneuver, which was, as she recalls it, moving the legs forward and backward gently to sort of dislodge any gas or stool. He instead doesn't listen to her. He does what he wants to do, which I'd suggest. He wants to stop the baby from crying, and he lifts up the legs, bends the legs, which is, by the way, where all the fractures are in the knees and on one of the ankles, and jams it
No,
into...
I understand, and I agree that that's why she was injured, but she didn't know that at the time. And the question is, if she didn't know that the baby was being hurt so badly, once she found out that the baby was being hurt, she told Mr. Amos to stop. And I know it sounds like he didn't, but there's no evidence to show that she
knew that he... there isn't, but there is evidence that a reasonable person would have realized, based on what had happened, that she had told him a maneuver and he hadn't followed her direction.
So leaving the child alone with him is what...
Is not a sufficient intervention. This is a newborn child, very, very fragile, 2.5 weeks to 4.5 weeks old, somebody who doesn't know how to hold a child and is making the child cry every time he's doing this maneuver that he's come up with. That should be enough to put a reasonable person on notice. This person should not be left with the child unsupervised because he's going to be hurt. She's going to be hurt.
So let's assume you win, and let's assume that after the decision comes out, you go to a birthing clinic and you're speaking to mothers and fathers and you're providing advice as to when they should remove the child from the care of the other parent. What do you tell them based on the decision you want us to write?
Pay attention to, you have a little tiny baby. It's very important to they can't talk. They can't tell you what's happening to them. You need to listen. If something's happening and they're showing distress, understand that.
When do you say it is a crime for them not to remove the child from that parent's care?
That will, when a reasonable person should have known the gravity of the harm, and this person at the very...
Didn't the doctor say that people, I mean, she didn't think anything was particularly wrong until the second x-ray happened. I mean, she didn't recognize the gravity of the harm.
She understood, well, being in the business, she understood there was a broken arm, and so a full skeletal...
Right, but just examining, I mean, but just when
No,
the child...
and there was testimony that fractures do get better, and it's unclear exactly how long it takes for a rib fracture to heal. It may hurt in the beginning, and then you get used to it. It's unclear. Clearly, though, it hurts, and a child would cry when the fractures occurred. That was very clear. It's unclear how long that pain would go on, but clearly the connection between the maneuver and the crying should be something to alert an ordinary person.
Is there evidence at all about, I mean, because even after these maneuvers and so forth, I mean, presumably the mother changed the baby's diaper, picked the child up, hugged the baby, rocked the baby, and so forth. Nothing to indicate the baby was sort of crying during any of those?
Just what Dr. Wilson testified was this was what you would expect. The child would cry and be upset. and would respond to that sort of movement.
Okay, so we just have the doctor suggesting what would happen in all of those instances, not any evidence that in fact it did happen.
No, the evidence we have is the defendant's recognition of this maneuver and what was happening. There is one other thing, the stool. This maneuver produced a stool, and the appeals court found that the compression was sufficiently forceful to produce stool, and that this is not the gentle maneuver that would produce a stool in a gentle way. This is forceful compression causing the child to defecate. So that, I suggest, might add to the mix.
The appeals court.
I'm sorry?
That's the appeals court.
I know.
I mean, no, I don't mean it's the appeals court and it's not us, but I mean, that's not the trial, that's not a finding from the...
No, and he was, as you know, the fact finder, and he just gave that one statement that clearly she knew that the child was being harmed before the guitar incident. I would ask you also if you might consider,
Time, but I'll give you 30 seconds.
okay, consciousness of guilt evidence. When the defendant first spoke to the first person she spoke to was Dr. Wilson. She did not tell her that Amos was doing this particular maneuver, even though she knew it, because she had already spoken to Amos about the maneuver on Memorial Day weekend and had learned that he had been doing this dipping and flipping and the baby crashed down. She doesn't tell Dr. Wilson that at that point. She also doesn't...
But that was after she learned of the broken bones.
No, she doesn't know, because she only learns the bones are broken when she talks to Silverio, which is Friday afternoon, I think around 3 to 5 o'clock. So her first interview is with Dr. Wilson, and she's not upfront about what she knows about either the bicycle maneuver or the knees to belly method.
All right, thank you.
Thank you.